The Supreme Court of Ohio considered a variety of legal issues when it conducted oral arguments in May. The court heard 8 cases, including a Fairfield County man's attempt to overturn his conviction for sex crimes. Jeremy Reed was indicted in 2022 on 22 counts of sexually related crimes involving 4 victims, all minors at the time of the offenses. The acts occurred over several years. Reed requested the Fairfield County Common Pleas Court order separate trials for each victim. A trial judge denied the request. Reed then appealed the judge's decision to not have separate trials to the 5th District Court of Appeals. The 5th District vacated Reed's convictions, ruling separate trials were necessary. The Fairfield County Prosecutor's Office argued that one trial for all 4 victims was appropriate, and Reed has not explained how he would be harmed. The justices questioned the prosecutor about the lack of details in Reed's claim of prejudice.
You're focused on the motion to sever as being boilerplate and that there was a non-specific statement of prejudice.
It seems as though the defense is requesting a special rule for sexual assault cases or maybe child sexual assault cases, that these cases charges are so prejudicial that they can never be joined together. This court has never stated that. This court has stated that it trusts juries to consider different charges and to follow limiting instructions that are given by the courts.
Reed's attorney argued that at a single trial, the testimony of each victim would be used to support the allegations of the others. He said that would be unfair because the jurors would not consider each allegation separately. The justices questioned whether a single jury could consider the case.
So you have an 18-year-old time span of 4 separate allegations. So doesn't that lead credence to the state's argument that it's simple and direct?
It's hard to imagine that a jury will not consider and reach the conclusion that, well, look, maybe 1 false allegation, maybe even 2, but not 4. How could that possibly be? And then convict on that. And I understand the state would much rather have it all together, probably for that same reason.
In his second case, Kenneth Brown was an admitted drug dealer, but investigators found he only dealt drugs on Tecumseh Street in Toledo. Alexandria Armijo bought cocaine from another Tecumseh Street gang member on credit. She planned to sell the cocaine to a customer in nearby Henry County and then pay the Toledo gang member back. She was caught and arrested in Henry County. Henry County prosecutors charged Armijo, Brown, and other Toledo gang members with engaging in a pattern of corrupt activity. Brown stated he had no connection to Armijo and could not be charged with a crime in Henry County, only in Lucas County, where Toledo is located. Brown was convicted and sentenced to 10 to 15 years in prison. He appealed to the Supreme Court, arguing the prosecution failed to prove Armijo was part of an enterprise that connected her to the Tecumseh Street gang. Because the two were not connected, Brown argued he could not be charged with being part of the drug dealing that Armijo did on her own. Justices questioned whether Brown and the gang benefited by selling drugs to Armijo on credit, and if that was enough to show they acted together.
What about the fact that she bought the drugs on credit, so to speak? So didn't the enterprise have an interest in her selling those drugs to get paid?
She still owed them the money regardless of what she did with the drugs. She still had to come back with $1,500 at some point. They didn't say how long she had to bring it back. If the court holds that loaning money makes you part of an enterprise, everyone takes out bank loans. If I buy from Amazon on an Amazon credit card, I don't become part of the Amazon enterprise.
The Henry County prosecutor explained how Brown was connected to the Henry County drug sales.
By fronting the drugs, having to return the money, and the amounts of the drugs that she obtained, it is more than just a buyer-seller, that she became part of that illicit organization to which Brown, in looking at the RICO statute, is responsible for. He is not responsible for knowing every action of every person of that organization, but because he is part of the Tecumseh gang drug organization, he then becomes responsible for her activity.
Chief Justice Sharon L. Kennedy announced the court will take the arguments under advisement and inform the parties of its decisions. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.